and be sure it's not anything evocative, anything that'll warrant more conversation. Because, like I said, we need to save that for the public meeting.
You can't send out a text among the group, if we have a group, let's say the 5 of us.
Yes.
And so you send out just saying, this is, don't forget about.
That's fine, yes.
Okay.
Reminders, hey, don't forget,
Yeah.
come here, this. But
Yeah.
if you start talking about, well, what are we thinking about this
Yeah.
agenda item? What are we,
Yeah.
none of that.
Right.
We got to keep that. But you can send out notifications. Hey, reminder, hey,
Okay.
remember, those kind of things.
Okay. Just want to be clear on
Yes, ma'am.
Yes.
Yes, ma'am. Alrighty. Can you attend a regular in-person meeting by telephone? The answer is most likely going to be no. Most times. You have to be in person. Say we only have in that 5-person council that I talked about earlier. Say we only have 2 people in at the meeting place, but one of them wants to call in. Say I'll call him so we can have a quorum. That's not that's against the rules. You can't do that. Everyone has to be in person. Um, and that's because any votes that are made have to be recorded in the minutes, which are public documents, and we don't want any people calling in via telephone. Yes, ma'am.
Does that extend, or that means it's just the council members, what if it's a city attorney or the mayor, what does that look like?
Yeah, no, the mayors and attorneys, anybody can, since they aren't council members, they aren't necessarily attending, they're attending as visitors or as people assisting in the meeting, but they aren't council members. So they aren't counting towards a quorum. They aren't the ones voting. Exactly. Yes, sir. So yes, that's okay. And a little later, I'm going to go over different ways the public can attend or view meetings, and that should answer your question. Alrighty, public comment. We've gone over exactly what a meeting is. Now we got to go over the rules of those meetings. The biggest one is public comment. Every single meeting of a public body has to have public comment. Before you vote on anything, I see this mistake often. It doesn't usually lead to anything because it's not super consequential, but sometimes I'll see boards, they'll even vote on their minutes. I vote to ratify the minutes of the last meeting. Technically, you can't even make a vote on that until you have public comment. The way most people does this, the way most public bodies do this, is they'll open up the meeting, they'll do their opening, their pledge, and they'll first thing, do we have any public comments regarding any agenda items today? You allow for that, and then you can move on with what you have. Since you're not a school board, school boards, they have to bring up public comments for each and every item. Because the city council is not a school board, you can just do that public comment right up front and get it out of the way, so to speak.
Question.
Yes, sir.
So that one time covers all of the events?
It certainly does.
Okay.
Unless, which I'll get to, if you add anything to the agenda, you'll have to bring it up again, but I'll get to that a little bit later, okay?
Okay.
Yes, sir.
My question would be, first of all, this initial public comment item or session.
Yes.
It has to be in the beginning because that's before any votes.
Any votes,
Yeah.
correct.
First of all. Second of all, most of the boards that I do work for have a 2 or 3 minute rule for public comments.
Yes.
And I mean, which dog's view of that?
Yes, there's a, well, but yes, you have to give a reasonable, there's no hard and line rule on what is reasonable. Each board can kind of, are allowed to give their own rules. 2 to 3 minutes, I believe, is fine.
The third thing is most boards that I do work for, and I've told them to instruct people to keep their comments germane to the actual agenda item.
Yes.
One of the problems you have is people come up and they have another agenda in mind, they start talking about all kinds of stuff.
Yes, sir. Yes, sir. It is within the board's rights to say, all right, let's keep it to the agenda items. Yes, sir. Yes, ma'am. Yes, ma'am. Yes, ma'am. And again, that's not a hard and fast rule. there's never, from what I know, there's never been any sort of ruling by the courts to say this is reasonable, this is not reasonable. But generally, 2 to 3 minutes is fine.
A point to make about that. Well, the time period can be limited for persons who want to speak. Anyone who wants to give public comment must be allowed to give that.
Yes, yes. So there can't be okay, we're cutting off public comments at 10 minutes, regardless of however long anybody. Every single person who wants to speak has to be given an opportunity to speak.
You're limited on a per person basis.
Yes.
Not on.
Yes.
Can that be also categorized as 2 or 3 minutes?
Yes, it's up to the board to kind of set a standard, and we would advise that once you set that standard, you be sure to adhere to it.
That's right.
No matter who is up there. Yes, ma'am. Yes.
So if, and I'm using hypothetical, because things happen.
Mhm.
And so if you had 50 people who wanted to speak,
Yes.
at the beginning, we asked the public comment, and, the people did a show of hands.
Mhm.
You see the room, everybody in here wants to speak.
Mhm.
At that point, can we say it will be limited to 1 minute per person because of the number of people in the room, or is it 2 to 3 minutes regardless?
I'm not too sure about that. I don't want to lead you guys to think that this 2 to 3 minutes is the limit or the minimum or the maximum. I was just saying that is acceptable. Whether or not 1 minute is acceptable or not, it's on a case-by-case basis, and I can't really tell you yes or no either way. Alrighty, I skipped over the public comment for school board since we're not a school board today, or ever. The council is not a school board. Executive sessions. Now, this is sort of an exception to the public open meetings law. The legislature does acknowledge that there are sometimes things that the council has to speak about in privacy, for various different reasons, which I'll go over next. But there is a procedure to that. In order to go into executive session, you need to have a vote on it. That vote has to pass by 2/3. So let's say we have that quorum of 3 people and that 5-person council. Thank you so much. 2 of those people have to vote to be, which is normal. It's a normal majority anyway. But 2/3 of the people present have to vote for that executive session in order to go into executive session. It's not just a majority. Does that make sense?
Yes.
All right.
Four have to.
Correct. Yes, sir. And always keep in mind, no final binding action shall be taken during the executive session. What you want to do when you're in executive session, you can go through the information that you have, you can talk about the information that you have, but once you start saying, I think we should do this, I think we should do this, you really want to avoid that. You don't want any final or binding decisions to be made out during the executive session. You can speak about all of the information you have. You can ask questions about the information you have. But anytime you start talking about the action that you think you should take based off of that information, that's when you're going to start getting into some issues.
I have a question before you go into executive session. Do you make announcements? Because I think we started doing it.
Yes, ma'am. You have to make a motion. Okay.
The public have any comments?
No, ma'am. You don't have to allow public. Well, if you allow public comment in the very beginning, you don't have to allow public comment on the executive session itself, because if you're going into executive session on an item that was on the agenda prior, then the public has already had their opportunity to have comment on that agenda. However,
So we don't have to do that.
However, if you bring up another agenda item that's not on the agenda already, and you want to talk and you want to go into executive session on that, because you're bringing in a new agenda item, you have to allow for public comment on that as well.
But if it's already on the agenda, we don't have to do it once he said it at the beginning.
Correct. Correct. Yes, ma'am. Yes, ma'am.
After, well, I might be getting ahead of myself.
You might be, but I'll let you go ahead and ask. Go ahead.
Oh, okay. After we come back from executive session, it's still, we just, come back and make a statement that, for the opening back up.
Got to come out of executive
Yes,
session.
you come out of executive session, you re-begin the meeting, and
Ask for public comments.
you can if you'd like. You don't have to, no ma'am.
That's what I want.
Once you've had that public comment at the beginning, you're okay. Now, there are different reasons to enter into executive session. Any discussion of the character, professional competence, physical or mental health of a person. Obviously, we don't want these sort of private issues of individuals out in the public, or at least we want to limit it. So you're able to go into executive session if you're speaking about anything like that. However, you have to give that person notice that you're going to be speaking about them in executive session, and that person has the right to say, you know what, no, I want this out in the open, I want it in the public. You can't go into executive session to speak about
But
it.
that's that person's call.
It's that person's call. It is it's kind of there, it's on them. It's on them to decide if they want it out in public, because this rule is there for them. This rule is there for their
Talk
privacy.
about the person that, we going into executive
Yes.
session about.
If
They
you're-
have a choice whether they want to be done in the public or they want us to go into executive session. And at that point, do they go into executive session with us to do the discussion, or how do that go?
They are allowed to be in the executive session, I believe. I'm not positive if they have to be there.
They don't have to be there, but
But
if they want to be,
If they want to be there,
that's how I just want
Yes,
to know
ma'am.
that. Yes.
and they have to have notice 24 hours beforehand. So,
That's why I asked the question, because, you know, you give them a choice. So if they want to do it openly, that's fine. But that does not mean that when we go to executive session on any board I've ever done, that they're not in the room. Because how can you understand what's going on to make, you know, to even understand what the problem is with anything? Example is when we doing stuff for firefighters and the disability is not approved or something like that. We give them a choice to go either or. And so they can tell us, you know, what their issue is. And that's why I asked the question.
Yes,
So
sir.
they make that choice, whether they
Yes,
want to go in or go out.
yes, sir. That's correct. Yes, ma'am.
That the person that's being discussed, has the right to be present in the conversation, from general practice.
I can't point you to a direct statute if there. I believe there is one. I'm not sure exactly which one it is, but it's a rule that they can be they're allowed inside of the executive session.
General discussion or even any point.
If the reason for going into executive session is to discuss the character, professional competence, or physical mental health of a person, then that person is allowed to go. If they're going into executive session for any other reason, no one has the right to go into that session.
That's a clarification.
Yes, ma'am. Yes, ma'am. Other reasons are strategy sessions, negotiations with respect to collective bargaining, litigation. This is lawyer stuff. Anytime the council is having legal issues, collective bargaining issues, things of that nature. Like I said, that's kind of a attorney-client privilege kind of things. Not necessarily that, but you want to keep your legal edge. You don't want that out in the open prior to getting your day in court. So that is a proper reason to go into executive session. Any discussion regarding security procedures for obvious reasons. Any investigative proceeding regarding allegations of misconduct. This is similar to number one. I'm not complete. I think number one keeps it to professional qualifications and things of that nature, but this is a little more severe. Any cases of extraordinary emergency, you can go into executive session over. This doesn't apply. This is for the Mineral and Energy Board. This is for school boards. anytime you're going you can go into executive session when you're discussing test questions, answers, papers, anything of that nature. Second injury board doesn't apply. And lastly, there's our catch-all or any other matter now provided for, or as may be provided for by the legislature. So just because it isn't in these 10 listed things, there may be other laws elsewhere that may say that certain boards are allowed to go into executive session. I would encourage you to look towards you in the revised statutes that apply to municipalities like this to see your specific ones. And like I said, no final or binding action shall be taken during an executive session. That's like I said, we don't ever want to get into, all right, I think we should do this, or all right, we're doing this, or anything like that. All right, this is your notices of the meeting. This is things prior to your meeting. All public bodies have to give a written notice of any regular, special, or rescheduled meeting no later than 24 hours before the meeting. And the agenda cannot change 24 hours before the meeting. You can change it. Say you send out notice 2 weeks before. Oh, something changes a week before. You can send it out. You can change it, send it out. But once you get within that 24 hours, there's no changing that agenda. What is reasonable notice? Your agenda notice, your notices should always include the agenda, the date, time, and place of the meeting. And each agenda item must be listed separately and with reasonable specificity. Before the public body can take action on the item must be read aloud. This is something to take note of as well. You can't just say, all right, on to the next one. How you vote, yay, nay. No, you have to read out each agenda item specifically. Yes, ma'am. And it has to be on the agenda with reasonable specificity. So the copies of the notice, when you're giving notice, okay, how do you give this? I have this notice written up. What do I do with it? You can leave it at the principal office of the body holding the meeting, which I guess would be here.
Outside the door?
Yes, sir, outside the door. The building in which the meeting is being held, which is also here, or the official journal of the public body. I'm not sure if you guys have an official journal.
We have one.
Okay.
We publish in the...
Okay, beautiful. So it sounds like you guys do all of it. So you could do all that, and if you have a website, which you do, I checked it out earlier, it's a nice website, you have to post it on the website as well.
Thank you.
Yes, ma'am. Notice must be given to any member of the public or the media who requests it in the same manner in which notice is given to members of the public. This is in addition. Say you've done all those proper notice, you get a member of the public coming to you directly and requesting a notice, you have to give them a notice as well. The notice must be given to the Commissioner of Administration. Alrighty. So let's say you're in a meeting, you send out that agenda already, the meeting comes up, and now you have something that needs to be added to the agenda. That's all right. You can do so. But it has to be unanimous. The entire public body has to vote and say, all right, we all vote to add this. The new matter has to be identified in the motion with reasonable specificity, just like all the other matters that you put in the agenda. And that also has to be entered into the minutes that you are adding this to the agenda. Now,
Public body, you mean the council?
I mean the council, yes,
Okay.
ma'am. Yes, ma'am.
They thinking that it's the public that's attending?
No, the public,
Okay.
yes, you're right. That is good to hammer down. Anytime I say public body, that will be
The council.
the council.
Okay. Thank you.
Yes, ma'am. Now, once you add that new agenda item, like I said earlier, because you're adding something that wasn't there before, even if you did your public comments at the very beginning, because you're adding this new agenda item, you have to allow for public comment on this as well. This is just a sample notice. Notice of meeting at the top. Whatever the name of this would be, the Baker City Council, the date, the time, the when, the where, and then you've got your agenda, call to order, roll call, public comment right up there at the top. New business, executive session. Now, this notice has it specifically saying, hey, we're going to go into executive session on that. That's not necessary. say you get into the meeting and you realize, oh, this is something we probably need to speak about in executive session. That's okay. You have to have it on the agenda, but you don't have to have executive session on the agenda. Does that make sense? Let's say executive session wasn't there, and Polly plaintiff versus Danny defendant was just number 3 under new business, and you decided once you got to it, oh, I want to go into executive session.
Yes.
That's okay, but it has to be on the agenda.
What has to be on the agenda?
The thing that you're going into executive session over.
The thing, okay.
That
But
you don't
have to have it.
you don't have to know beforehand that you're going into executive session,
Okay.
but you have to have the thing you're going into executive session over on the agenda.
Wouldn't that kind of what you said earlier about if they plan to go into it, you got to give the person 24-hour notice? So
Yes, if it's for that particular thing, yes. But if it's for any other reason that you can go into executive session, then that will apply. But you are correct that if you are speaking about someone, as I went over earlier, their professionalism, whatever it may be, you do have to give them notice.
the practice to put executive session may be required, would it be on the safe side?
That's up to each board. That's up to
I
each
don't
board.
think we need.
We don't know. So a lot of times, when something like this, you might put something on the agenda if it's not dealing with a person or something.
Correct.
And then the attorney might say, it might be something that we need to go in and talk about. We put it on the agenda, and he might come out and say, we need to sit down and talk about it so we can make the best decision
Correct.
when we come back out.
Correct.
And so that's why sometimes you just put it on there, and then you can go in executive session, but you still have to follow
All the same rules.
Right.
Two-thirds vote.
Right.
I don't know if I said it, but the vote has to be what they call veto. No, it's two-thirds.
2/3.
Veto voce has to be out loud. Yay, nay.
Okay.
That sort of thing.
All right.
All righty, the minutes. You also have to have a minute for each of your meetings. At minimum, they have to include date, time, place of meeting, a lot of similar stuff to the agenda. Members of the public body that were present and absent. The substance of all the matters that were decided at the meeting, and any other information that the public body requests to be included. So again, public body means the board or the council. So that's just saying you can put whatever you want in the minutes, but it has to at least include these things here: date, time, place of the meeting, people present, and what went on at the meeting. Here's a nice sample of the minutes. You'll see it looks a lot like the agenda. That's all right. Just add the members present, members absent. All right, recording. All proceedings of a public meeting may be video or tape recorded or broadcast live. Each public body, each council, each board can make their own decisions as to their standards for recording, but they can be recorded. Any non-elected board or commission, that will not be you guys, so don't worry about that one. Records of the proceedings, if you do record your meeting, it has to be available to the public for at least 2 years from that date. Just keep most boards put it on their website, make it available there, but 2 years that's going to be your time.
So, question.
Yes, sir.
So, we live, so it's there on the website.
Yes, sir.
If anybody comes in and they want it, they have to do a public records request to get it. If they want to get it separately than what we already have on the website.
Say that again. I'm sorry.
Okay, so we record live, but in some instances we have people who come in and they want to get the whole. I don't know, what they're looking for, but if they came in and they said that I want to get the recording from last night,
Yes, sir.
they do have to put in for a public records request, right? Is that a public records request? Because we already have it on the website anyway.
Yes, sir. Yes.
It's already-
If you have it on the website,
Right.
you're good. It has to be available. And if you have that on the website, that's fine. If they come in for the public records request, I guess that's their way of doing it. But yes, sir.
But that's a whole different process. See, public records request is a whole different process.
Yes.
To put the process in doesn't mean that you can get it right then and there. You have to go through the process.
No, sir. If you have it posted online, if
Right.
it's available for them to see online, yes, you can have your own process with the public records request.
And that's why go ahead, sir.
I'd like to point out, so Tyler, my name's Jetty Smith, by the way, I'm the Attorney General's office. Tyler this whole presentation is on the open meetings law. The public records is a whole another set of statutes, separate scheme, and we have a whole different presentation for public records. So while you're getting a good bit of the open meetings law presentation here, if you want to know about the the public records law or dual office holding or some of the other presentations, we have those presentations available at the Attorney General's office, and I commend for you all to sign up for those because there are some technical rules. For example, you asked if they have to be made available immediately. If somebody wants to inspect public records, they are entitled to inspect them immediately unless they're not available for some reason or another. If they want copies, then there's a process for an acknowledgement letter to be sent out. If there are exceptions for producing it, for those to be provided in writing to the requester. So I'm affirming for you that there are different rules, and those are technical, and we also have a separate training on those if y'all are interested.
We've heard them at LMA. I was asking because that's the same question that comes up all the time because you post live. When you post live, that public record is out there of the meeting. But some people still like to come in and get it for whatever reason. And so that question comes up a lot. You guys give that presentation all the time down at LMA. So, we've had it a lot. But I appreciate you answering that question.
Yes, sir. Thank you for picking up my slack there. Alrighty, live broadcasting. Each governing authority of a municipality with a population of at least 10,000. Baker has, I believe, around 12,000, closer to 13 than 12. So you all have to broadcast your meetings live, which it sounds like you do. Notice of the meeting, along with that notice that we went over, you also have to provide information on how members of the public can access that live broadcast. Put on there a Zoom link or what have you, a website for them to go to access that live broadcast. Alrighty, so we have exceptions. We're in hurricane country. We've got exceptions for disasters. A public body, this is when they allow you to meet via electronic means. If the governor has declared a state of emergency or disaster involving this geographic area, if it's over there in Lake Charles and the governor hadn't said anything about Baker, that doesn't apply to the Baker Council. It only has to affect your geographic area. The public body and its presiding officers have to comply with all of the following requirements.
Okay, so question, COVID scenario, I guess we're here too. When it says disasters, but is there anything out there for if we have COVID and you can't come together, the governor says that he makes a declaration that we can't be, in this, like we were before. Yes. And then we still have to do the meetings and we can still have.
Yes, sir.
Okay.
For those situations, I believe the government, it would be considered a, I don't know how to go back on my slide to see the exact.
I got it. Right.
Yes, sir. Presiding officer of the public body has to certify on the notice of the meeting that the agenda of the meeting is limited to matters that are directly related to the emergency, matters that if delayed will curtail vital public services, matters that are critical to the continuation of business of the public body, or other critical and time-sensitive matters that the determination of the presiding officer should not be delayed. Basically, this is saying that you can call this emergency meeting, but things have to relate to the emergency. And at the bottom, you have that kind of catch-all that is like, okay, maybe it's not related to the emergency, but it's still very time-sensitive, and we need to have a meeting about it. Then the board can vote to hear that matter anyway, even if it's not directly related to that emergency meeting. It has to be a 2/3 vote. But other than that, all items have to pertain to the emergency itself.
Yes, sir.
Notice requirements. for those emergency meetings are the same, except for one thing. Obviously, in a lot of emergencies, it'll be difficult to send out things as you typically would. So, in addition to these emergency meetings, you have to distribute your notice to all known news media outlets within your area, within the jurisdiction of this body. Because if anybody's going to be able to send out notice, it'll be them during disasters. And also, any public body or news media that requests that notice, you have to send it to them as well as put it on your website, which you guys do anyway. Other requirements, you have to have a way to receive public comment electronically. If you're having an electronic meeting, you have to have a way to receive public comment electronically. You have to identify and acknowledge all public comments during the meeting. You know, with Zoom, with COVID, people would be comments. So it wouldn't be someone calling in, you wouldn't hear voice, you'd be seeing comments. Well, you couldn't just ignore that comment from the public because you want to move on. You have to identify each public comment. And you have to maintain the comments in your record of the meeting, your minutes, any recording that you have. Each person has to be properly identified. For Zoom, you got your little name under there. But if it were any other means, you have to properly identify yourself anytime you're speaking or present or voting.
What is proper identification?
It could be, hi, I'm Councilman such and such, and then get on with it. Just say who you are. Make sure there's no voices from the void that we don't know who's talking and whatnot. All parts of the meeting, excluding any matter discussed in executive session, must be clear and audible. You have to make sure you have all your electronics up and running. Make sure everything's, I know we're kind of at the mercy of Zoom sometimes, but we got to do our best to make sure everything is clear and audible. Don't want to do anything without the public being able to understand it. Alrighty, so you have electronic meetings. So basically, there's two sections of this. You have the electronic access to regular meetings, and you have public bodies meeting via electronic means. So you have your typical meetings here. There are also rules for whether or not members of the public can attend this meeting via electronic means. The Americans with Disability Act defines a disability to mean a physical or mental impairment affecting major life activities, a record of such an impairment, or being regarded as having such an impairment. The reason we bring this up is because you have to allow access to anyone with a disability who may not be able to make it in person. Any member of the public who wishes to attend, who wishes to make comment, you have to provide some way for them to participate, and that's usually the easiest way is through electronic means. Well, that's how you go back. All righty. I got it now. All righty. Is your public body capable of allowing a person with a disability to participate in meetings electronically? If yes, you have to adopt rules for participation for any such person who prior to the meeting requests that accommodation. So if the board does not already have rules in place for, if the council doesn't already have rules in place for how you would accommodate someone with disabilities to attend the meeting electronically, I recommend you do so as soon as you can. Now, this is by request. It's nice to always have it available, but it only becomes an obligation if someone requests it.
So they'll have to call in and request that they need.
Yes, ma'am.
Yeah.
Alrighty. Does your public body have a member with a disability recognized by the ADA? If so, it applies unless the public body is the legislature or parish board of election supervisors. So that doesn't apply to you all. But if you do have a member, I'm not going to get into it, but if you have a member of your council who has a disability, you have to allow for them to be a member of the meeting, be a part of the meeting via electronic means. Public body has the powers, duties, and functions that are not limited to a particular political subdivision nor region. That is not you guys. Public body conducts it, so this doesn't apply to you all. Alrighty, so this is more meetings via electronic means. This would be if you all did have, well, I'm going forward again. There we go. Let's go back. All right, let's go over our glossary, our terms. There's an anchor location. Anchor location is if you're having an electronic meeting, the anchor location is the main part. It would most likely be this room that we're standing in here. This is where the main action is happening. Meeting via electronic means, that means anyone coming in via Zoom, Skype. I don't know if anybody uses Skype anymore. Teleconference is a conference made via telephone, and video conference is the same thing, just with video. You can see them. Oh, there I am going backwards again. Alrighty, you have to adopt rules and regulations and procedures to allow the public to participate via electronic means. You may only have meetings via electronic means up to 1/3 of regularly scheduled meetings in a calendar year. And you have to limit the number of successive meetings via electronic means. I think this does not apply to you all because you all weren't in that exception that I said earlier. So we're going to skip ahead. I apologize for wasting your time with that. Let's go here. Okay. All right. Alrighty, so we're going to go into enforcement. Bless you. Revised Statute 4225 provides for who can enforce the provisions of open meetings law. That would be us at the Attorney General's office, the district attorney down at the 19th JDC, and any person who's been denied any right to an open meeting. Anybody who thinks that the rights, the rules of the open meeting law have been violated, they have the opportunity to file suit against that public body, as does the Attorney General and the district attorney. The penalties are a writ of mandamus, injunctive relief, declaratory judgment, judgment rendering action void. A lot of these are legal terms. Writ of mandamus is a judge saying, ordering someone to do something. Declaratory judgment is the judge just declaring something, saying, hey, by all intents and purposes, this thing is what it is. They get to tell you what it is. Judgment rendering action void. This means that they can say whatever happened. No, it didn't. It didn't happen. Awarding there can be civil penalties awarded to anyone who is found to have been aggrieved by a failure to follow open meetings law. They can be awarded attorney's fees and costs, but the suit must be brought within 60 days. Car accidents and 2 years now, but with these things, you only got 60 days. Civil penalties. Any member who knowingly and willfully participates in a meeting violating this principle shall pay up to $500 per violation. They are personally liable. Like I said, the suit has to be brought within 60 days. That's Revised Statute 4228. Alrighty. That was quick. Didn't feel like it up here, but do we have any questions for me?
Let me ask you this.
Yes, sir.
Is this online somewhere? Can you get a hard copy of that?
I believe it's online. I'm not sure.
It's there. LMA has it. LMA has it in your book, Dr. Vincent. Dr. Vincent.
Yeah.
LMA has it in your handbook. They have it updated in your handbook, and they have it online too.
Okay.
Yes, sir.
Yeah. He knows I'm a historian.
Yeah. Well, you like the book. You like to hold it in his hand.
But that's
Has to pass out here is the open meetings guidance that our office has provided. It's a recitation of the statutes with some borders of open meetings law opinions that we've rendered over the years from the Attorney General's office.
okay.
I would caution caveat, this is a good summary of the open meetings law scheme, the statutes, and then some relevant Attorney General opinions. It's not all the Attorney General opinions, I don't believe, but reviewing this packet is really useful for getting a good sense of what the open meetings law requires in addition to the presentation.
Okay, because I love these Louisiana revised statute numbers, and sometimes you can go back and look at them. I didn't get them all down. And,
Yes, sir. Yes, sir. I apologize.
No. You did a great job.
Thank you. Anything else?
All right, thank you. Let's give him a big round of applause there.
Yeah.
Thank you, sir.
All right. Okay, so I'll entertain a motion to adjourn. Can I get a motion?
I make a motion that we have questions.
I got it. You're right. We got it. We got a second?
Second.
Any questions? Any comments? Any questions? Any comments? We are adjourned. Thank you.
Good. Thank you so much.